She was awakened to the sound of somebody in her carport, what sounded like, according to her, hitting her car, trying to get into her car. She saw the defendant in her carport. She yelled out at him to get off of her property. At that point, he became very angry, broke a window on the carport door. She then went inside of her house to retrieve a shotgun. There was an outdoor patio on the back deck on the back of her house. The defendant went to the back of her house and then broke out some windows in the back of her house. She pointed the shotgun through one of the broken windows. He grabbed the shotgun out of the window from her. She then attempted to flee from the front carport door again. He intercepted her there. He threw her on the ground. According to her, he stomped on her chest. He then dragged her through the carport inside into her house, into the kitchen, where he got a kitchen knife off of her counter. He stabbed her at least 3 times in the neck, left her with very serious injuries. The doctors that we spoke to who worked on her said that she was very fortunate to still be alive. She called 911. There was also a neighbor, a family that lived next door. Those are the Shabazz family that's related to the final count in the indictment, the attempted burglary. They heard some of the commotion, and they said that the defendant, after he left Miss Carswell's house, he then went to their house and started trying their door and attempting to get into their residence at that point. The shotgun that the defendant grabbed from the primary victim was later discovered in the Shabazz's backyard. The police arrived on scene. They did find the defendant with blood on him standing in the backyard of Mrs. Carswell. He had injuries to his hands, we believe was from the glass and perhaps from the knife as well. He was taken to, I believe it was Grady, for his injuries at that point. We did GBI testing in this case, and the victim's DNA was found on the defendant's clothing. So that would have been her blood on him. The defendant was taken to DeKalb County Jail. Mr. Issa and Mr. Majeski filed orders with the court to have him reviewed for competency and to have him reviewed for criminal responsibility. The expert, who I know the court is now aware with because of witness arrangements, Dr. Gambow with DVHDD, she evaluated him and found him to be legally responsible and competent to stand trial. I will let Mr. Issa speak more about this, but the defense also had an expert who reviewed Mr. Johnson's history, met with his parents, and met with Mr. Johnson, who found that he was likely suffering from some form of psychosis in the weeks and days leading up to this incident. Not our expert, but the court's expert also reviewed the report from the defense and took that into account. And Dr. Gambow said that did not affect her findings, that she still found him to be responsible and competent for the incident. We have had significant negotiations, the state and the defense, and we have come up with a resolution that we hope Your Honor will follow this morning. What we're going to ask the court to do is accept the guilty plea today. Mr. Johnson will enter a guilty plea to counts 2 through 8, and it'll be guilty but mentally ill. We have agreed to null pros count 1, that's home invasion. because we are uncertain if the shotgun was actually ever brought into the house by Mr. Johnson. So we would, the state would ask the court to allow us to null pros count 1. We are going to reduce count 2 to regular kidnapping instead of kidnapping with bodily injury. And at a later date, ultimately, Your Honor, we would ask for kidnapping on that count for him to be sentenced to 20 years to serve. That is non-parolable time. He'll get credit, obviously, since he was been in custody since December 28, 2018. We'd ask the court on count 3 for 20 to serve concurrent to count 2. Counts 4 through 7 would be 20 to serve on probation to run consecutive to counts 2 and 3.
Hold on. Counts 4 through 7, 20 to serve consecutive, but on probation?
Yes.
So it's not 20, it's not 20 to serve, it's 20 years probation.
On 4 through 7. Right.
Thank you. Thank you.
So
Okay.
2 and 3 would be the serve time. So it would be 20 to serve on those 2 counts. And then the rest would be consecutive. And count 8 is a max of 10. So that would be 10 on probation consecutive as well. So yes, it would be 40 to do 20 with the balance on probation.
Okay, got it.
In the meantime, Judge, we've submitted an order for the court to sign for us to have a Dr. Ralph Norman come into the jail on July 28th and do a full psychiatric evaluation of Mr. Johnson, that is a psychiatrist, and to have a final mental health diagnosis for Mr. Johnson before he goes to the Department of Corrections so that he can be medicated if that's what needs to happen, and to have a prescription on file before he goes to the prison system. So I think what we're going to ask you to do today, Judge, is withhold sentencing. That is what the sentence that we have agreed upon, but to withhold that so that he can be evaluated in the jail. And I think for us to come back in, I would say probably 2 months, and to have the sentence imposed at that point.
How do you know how long it'll take the doctor to do or to complete his evaluation? Is he going to prepare a report or?
Yes, I think he will complete it, the in-person evaluation that day, but we don't know if he'll want to come back and take another look after he's prescribed medication. So we just thought
Got it. Okay.
have a little more time.
Yeah, I'm looking for a next July 28th. August. We could do it, I don't know if there's a time in August that would give him enough time to get his report done. But we could do, we have a miscellaneous calendar Friday, September the 8th, if that works for everybody.
I think that could work for me.
I really love the event, but
You think? Okay.
I just think that I'm murdered. But they rescheduled that for the 17th. So
Okay. All right. Perfect. All right. We'll add this then to the September 8th miscellaneous calendar for the sentencing. Okay. Assuming we get the report back. Obviously, if there's a holdup, I will understand and we'll just reset it. Okay. Mr. Ingram, does that work for you?
Yes, that's
Okay.
fine. And I just want to put one more thing on the record before I finish. We are going to ask that once he's released on probation, that these will be special conditions, that he comply with any mental health treatment, continue medication as mandated or recommended, that he provide a HIPAA release to the probation department, and that he have no contact with the victim or victim's families, and that he not return to the incident location. I think that's all I have, Judge.
Okay. Anything you all would like to add?
Your Honor, I believe anything we get, I apologize.
You're fine.
I think that anything we'll add will only come in.
In terms of the sentencing.
September.
Okay.
At this point, I'd like to make sure that we get to the plea with this gentleman.
Understood. Okay. All right, then let's go forward with the colloquy. Sounds like there's a factual basis for the plea. All right. We're going to swear you in, Mr. Johnson, okay?
Kevin Johnson.
And Mr. Johnson, what is your true, correct, and legal name?
Kevin McKill or Kevin Michael Johnson.
Okay. And are you the same person who was charged in this indictment?
Yes, sir.
And are you able to hear everything I'm saying today?
Yes, I can.
Are you under the influence of any alcohol, drugs, or other medication?
No.
Has your lawyer explained the charges against you today?
Yes.
And have you had enough time to discuss your case with your attorney?
Yes.
Did you discuss and review your case and this plea transcript with your attorney before court today?
Yes, I did.
Did you understand that if you have any questions during the plea, you have a right to speak with your attorney in private?
Yes.
And is your decision to go forward with this plea hearing today knowing and voluntary?
Yes.
Do you understand you have a right to a jury trial?
Yes, I do.
And do you understand that you could have a jury trial by pleading not guilty or by remaining silent and not entering the plea?
Hold on 1 second. 11 and 12 were not checked. So the clerk can do it if counsel gives permission for her to make that adjustment.
We give permission, Your Honor. Absolutely.
Okay. So the answer to, will you repeat question 11, please?
Mr. Johnson, do you understand you could have a jury trial by pleading not guilty or by remaining silent and not entering the plea?
Yes.
And do you understand that by pleading guilty today, you're waiving all defenses?
Yes.
And do you understand you have the right to assistance of counsel during the trial of your case?
Yes.
And do you understand that you're entitled to a presumption of innocence?
Yes.
Do you understand that you have the right not to incriminate yourself?
Yes.
And do you understand that at a jury trial, you have the right to question witnesses against you, subpoena witnesses on your own behalf, and to testify for yourself and offer other evidence?
Yes, I do.
And do you understand that by pleading guilty, you are giving up all of those rights?
Yes.
Has anyone made any threats or promises to influence you to enter this guilty plea today?
No.
You understand that if you're not a citizen of the United States, plea of guilty will have an impact on your immigration status and you will face deportation.
Yes.
Have you had enough time to discuss this case thoroughly with your attorney?
Yes, I have.
Is your attorney Mark Issa?
Yes.
Are you satisfied with the services and advice of your attorney?
Yes.
Do you understand that your attorney and I are making a negotiated plea request with this court?
Yes.
And do you understand that we are making the following recommendations? That at a later date, you will be sentenced, that we're agreeing to null pros count 1, that we're agreeing to reduce kidnapping with bodily injury to kidnapping, that we'd ask the court at a later date to sentence you to 20 years to serve on count 2. On count 3, we'd ask for you to serve 20 years to run concurrent with count 2. And on counts 4 through 7, we'd ask for a sentence of 20 years to serve on probation to run consecutive to counts 2 and 3. And at count 8, you would be sentenced to 10 years to serve on probation to run consecutive to counts 2 and 3. Do you understand all that?
Yes, I do.
And do you understand that while in probation, you will comply with any mental health treatment, continue medication as mandated by the probation office, that you will provide a HIPAA release to probation, that you're to have no contact with the victim in this case or the victim's families, you're not to return to the incident location, you will get credit for the time that you've served since December 28, 2018. Do you understand all of that?
Yes, I do.
Do you understand the maximum penalty for the charges that you're entering a plea to today is 130 years?
Yes, I do.
Do you understand that Judge Heydrich is not bound by any promises or recommendations, and that she can impose up to the maximum penalty and mandate that you serve the charges consecutively?
Yes.
Do you understand that if the judge imposes a sentence greater than our negotiated plea, you have the right to withdraw your plea at the time of sentencing?
Yes.
And do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction and other jurisdictions, including in federal court?
Yes.
And how do you plead to counts 2 through 8? Guilty or not guilty?
Guilty but mentally ill.
Okay. And are you in fact guilty but mentally ill?
Yes.
And do you want to plead guilty today?
Plead guilty but mentally ill.
Yes, guilty but mentally ill, sorry.
Yes.
And have you and your attorney discussed your habeas corpus rights?
Ask the question one more time, please.
Have you discussed your habeas corpus rights with your attorney?
Oh, yes.
And do you understand that you have 4 years from today's date for a felony offense to file a habeas corpus petition with respect to this guilty plea?
Say it one more time, please.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition with respect to this guilty plea?
Yes.
And do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
And do you have a weapons carry license?
No.
Do you understand that you're not allowed to possess a firearm?
Yes.
And have you understood all the questions I've asked today and given truthful answers to the questions?
Yes.
That's all I have, Your Honor.
Okay. Anything else?
Not at this time, Your Honor.
Okay.
Sequel to you.
Sure, all right. Then I will accept the plea as being freely and voluntarily made. I find that you understand the consequences of entering the plea, as well as all of the constitutional rights you're giving up by entering the plea. And I will accept your plea of guilty but mentally ill, and we will defer this case for sentencing until September the 8th. Of course, that is contingent upon the evaluation having been completed by then. If for some reason, counsel, it is not done, just please reach out to Benita ahead of time and we'll reschedule it so you don't have to come in here and waste your time if we're not ready to go forward.
Thank you.
Okay. Mr. Ingram, was there anything else?
No, Your Honor.
Okay. All right, Mr. Johnson, good luck to you, and we will see you back here on September the 8th. Okay?
Okay.
All right,
Your
thank
Honor.
you.
Thank you. Can we be excused, Judge?
Yes. Was there anything else?
I'd just like to thank the court.
I'm sorry, I couldn't hear you.
I'd like to thank you and Mr. Ingram. This has been a very difficult case. I always had a lot of respect for both of you. And
Thank you.
the professionalism that's shown here.
Thank you.
Appreciate it.
I know it was, oh, he needs to, okay, but Deputy, I forgot, before you take him back, he does need to, I always forget that part. He needs to sign the plea colloquy. Okay, sorry. Well, thank you. We appreciate your professionalism as well. This has been around for quite a while, and I'm glad we were able to find a mutually agreeable resolution.
Yes, sir. It's a tough one. You want me to wait for the sign?
Yeah, wait, somebody wait with him while he signs it, just to be sure. I need to put like a big Post-it note, remember, for him to sign the colloquy.